Right, and good afternoon and a very warm welcome to everyone who is joining us today. My name is Katherine and I'm a postdoctoral fellow at the Bonavera Institute of Human Rights and co-convener of Oxford and Business and Human Rights Network. Today we are hosting a webinar on the role of a regulator in monitoring and enforcing human rights due diligence, and it's very exciting for us to be collaborating with Kingsley Napley, an internationally recognized law firm in London. Thank you very much to everyone in the firm and to my colleagues in Oxford who helped to put this event together. And it's a pleasure for the Institute and the network to provide a forum for this very important discussion. The chair for today's event is Professor Robert McCorquodale, who is a longtime friend of the Bonavera Institute and the network. Robert is a professor of international and human rights law at the University of Nottingham, a barrister at Brick Court Chambers in London, and the founder of Inclusive Law, a consultancy on business and human rights. Robert, it's nice to see you again, and I leave it in your hands now and let you lead the discussion.
Thanks so much, Katja. I'll begin with three thank yous. Firstly to you, Katja, Lisa and Katherine from the Bonavera Institute for enabling this to happen. Secondly, my thanks to Fiona Gooch and Tom Wills from Traidcraft Exchange for just the vision and drive to make sure that this report even came into being. And my thanks to Rachel, Sophie Kemp and Katherine Tyler for the thought and the kind of ability to bring together the report in the excellent way it is. And I would encourage everyone watching to read the report, which is found on the link to this event. There's just a direct link there, and I think it's a really clever report, but also one which, as far as I know, no one else had ever done. So it's very valuable. And so that's just my three thanks. And then to introduce the speaker, just very briefly, Fiona Gooch is the Senior Policy Advisor at Traidcraft Exchange. In this role, she works to improve the impact UK-linked businesses have on vulnerable farmers, workers and communities in the Global South. She's also worked in the Global South. And I know from my own experience, she's a fearless and determined campaigner. The next speaker will be Dr. Rachel Chambers. She's at the University of Connecticut in the US, as well as being a barrister in England and Wales. She specializes in intersection of business and human rights. And I do know that she has had worldwide influence in the activities that she's undertaken. And finally, Sophie Kemp is a partner at Kingsley Napley LLP, specializing in judicial review, large-scale investigations, inquiries, business and human rights issues, and working extensively with regulators. She is rightly, in my view, described by Chambers 2021 as an impressive lawyer and a contributor to public health. So you've got three great speakers. Just to say, the format is they'll each present their papers for a total of about 35 minutes, and then we'll go to questions. We're also having plenty of time for questions. And remember, we're recording this session. Please do put your questions in the Q&A. They're not in the chat box in the Q&A during and after the presentations, and I'll gather them to ask the panelists. If we don't get to all the questions, the panel have kindly said that they'll do their best to follow up afterwards. Just to remind you, as I say, of the question and answers. So we'll now begin, and we'll get Fiona, please, to begin with your presentation. Thank you.
Thank you very much, everyone. And I hope you can hear me. Robert, can you give me a thumbs up? No, you've disappeared. Yeah, thank you. Great. So huge thanks to Bonavera and to Robert for organising this. And I'm just going to quickly explain who Traidcraft Exchange is and then why we, along with other NGOs, commissioned this report. So first of all, just to explain about Traidcraft Exchange. It's an international development NGO that focuses on trade and business, and we run programs in South Asia and East Africa to support farmers and workers in supply chains. And importantly, we campaign in the UK for policies that bring about more just forms of trade. We have a long history of working with businesses to improve the fairness of their supply chains, but increasingly we are recognizing that there are laws that are needed to create a level playing field to ensure that businesses act in the right way. This picture is of Mary, who is the wife to Samuel, who was shot at a mine operated by a British company. She physically has to carry him everywhere and they have no income. I now want to just talk about why we need to look at the cross-border impacts of human rights violations by the UK-linked companies. The crucial thing to say is decisions and actions made in the UK have widespread and sometimes devastating impacts. In 10 years running up to 2014, the Business and Human Rights Resource Centre received 303 allegations against 127 companies. These accounted for 13% of all the global allegations that they received. The vast majority of these cases relate to harms that have occurred in other countries, mostly the global south. And as you can see from the numbers, some companies have repeated allegations against them, sometimes for different subsidiaries or operations. UK corporate malpractice is also a cross-sectoral problem. At the moment, multinational businesses operating in the UK are able to act with impunity, and I'll just take you through two examples. In 2015, my colleagues visited the Zambian copper belt to meet with communities living next to a mine run by a UK company called Glencore. The mine emits noxious gases, poisoning the surroundings, causing lung problems and skin problems, but also corroding the metal roofs of nearby houses. Just imagine what that is doing to people's bodies. This young woman, Bertha, is coughing all the time because of the gases that are being emitted, and there have even been allegations of death. In 2019, Traidcraft Exchange colleagues met with communities in Liberia who had had their land taken from them by British company Equatorial Palm Oil. This is a land grab. The communities did not consent, they have not been compensated, and they are now destitute. So why law? Well, essentially it's because it is very clear from years of experience that voluntary action is incapable of changing British businesses' activities in this space. And that's due to the fact that they've got competitive pressures, shareholder return pressures, and they have failed essentially to develop meaningful objectives and indicators that are not about profit. So businesses now seem to be reluctant to take decisions that could threaten the bottom line. The UNGPs only provide a soft law framework. Hard law is needed. Perhaps individuals should be made liable. There should be severe consequences for malpractice, and they need to be significant financial consequences, possibly in the form of compensation and or dissuasive fines. And there should be personal consequences for directors or senior managers. Then we will change behavior. So I wanted just to highlight that there's been a fashion to look at reporting. This hasn't changed practice. Recently, the 2020 human rights corporate human rights benchmarking report that looked at 230 companies highlights a major disconnect between the commitments and processes of a business that they report on and the actual performance and results on the other. What they're saying is the disconnect between processes and reporting and action is becoming apparent. Ultimately, we need to ensure that action changes, and we need law to do that. We want to see a human rights due diligence law that puts a positive obligation on companies to consider the potential human rights and environmental impacts of its decisions and actions, and then to ensure that it doesn't cause those violations. If the law doesn't stop actual violations, if the company doesn't stop those potential violations, then the company becomes liable. But then the question is, how on earth do we do enforcement? So that is the purpose of this report. There's growing consensus amongst NGOs, legal professionals and the business world that there is a need for law in this space, because essentially these human rights and these environmental impacts are significant and deserve a proper response. different laws are in process in France, Switzerland, Netherlands, and the EU. And most importantly, there's public support. In November 2016, Traidcraft Exchange campaigners presented a petition with more than 20,000 signatures to number 10 Downing Street, highlighting the need for change. And in Switzerland, their proposal gained more than 50% of public support. And positively, the EU is also exploring action in this area. So there's momentum, there's interest in human rights due diligence, but how would this law be enforced? There has been no action in relation to the cases that have been brought to the attention of Business and Human Rights Resource Centre in the space of criminal law. There's been insufficient action in relation to personal injuries. There's been no action in relation to a breach of directors' duties. All of those perhaps could have been relevant if there was scope or space for enforcement, but there doesn't seem to have been so far. If some of these allegations had happened in the UK, then it would have been the role of a regulator to act. The Health and Safety Executive, possibly the Environment Agency, Crown Prosecution Service would be a different route. So I wanted to thank hugely Rachel and Sophie and also Katherine for the work that they have done to explore what a regulator could look like in this space, so that if we get a law and when we get a law, it'll be properly enforced and we really, really will see change of British businesses, so that we as consumers can have confidence when we go shopping that our money is not being spent on human rights violations. So I will leave it there and want to say huge, huge thanks to the authors for this amazing work that they've done. And I've put the picture of a snail on the bottom because I am desperately hoping we will not take years and years and years to get to having enforcement and a decent piece of law. So thank you for your time.
Thank you, Fiona. I loved your pictures and your kind of passion behind this. I just want to pick up one point, which is you refer to the lack of any criminal cases at all in the UK in this area. Was that one of the motivations for your innovative decision to seek a report in this area about a regulator?
That's correct. So we've seen a handful of civil cases, and it's brilliant the work that's been done to bring those to court. But the subject matter relates to things that are criminal, beatings, death, and then the other area is where people's entire livelihoods go, but in an area that should have been regulated perhaps. So that is what led us to think about a regulator possibly might help us marry and balance criminal and civil together, and also recognizing you need really good specialist knowledge in this area. Courts are expensive and lengthy processes. A regulator actually might be much, much more efficient. So I hope that helps a bit of background. An investigative function is absolutely crucial. Amnesty International proposed that the Met Police should investigate Trafigura. It ended up with the Environment Agency, and the Environment Agency ducked it, not on grounds of whether or not the action was or wasn't criminal. They said if it was, it would fall in their court, but they couldn't face the scale and the length of litigation that would come if they were to pursue a course. That is a terrible, terrible thing for a British regulator to say, because it lets big, complex companies off the hook.
Good point. And the lack of skills in the prosecution is another reason, of course, which you're saying in that. Thank you. That's really helpful. Thank you so much for putting this context so well and powerfully. Thank you very much. And now the next speaker is Rachel. Over to you.
Thank you, Robert, and adding my thanks to Bonavero Institute for hosting us today. Thank you so much. And also to Traidcraft Exchange for the opportunity to conduct this interesting research this year. So what I'm going to do in my short introduction is really introduce the law that is the basis upon which we conducted this research, and then talk about some of the considerations that came into play in terms of civil law and criminal law, and why these cases haven't been able to come to fruition in the English courts. So in terms of the proposed law, the basis of our research was what's called a principal elements document. So a document prepared by a coalition of UK civil society organisations, including, of course, Traidcraft, and under the umbrella of CORE, of course, who are working to strengthen corporate accountability for human rights abuses and environmental damage. So the principal elements sort of provide the summary of what they would like to see in new legislation. And it's intended to facilitate dialogue with policymakers, business, academics, etc. So just to outline what this principal elements document says, first of all, the first principle is that commercial and other organizations have a duty to prevent adverse human rights and environmental impacts of their domestic operations and international ones, and their products and services, including their supply and value chains. So that's the duty. And then in respect of that duty, commercial and other organizations must develop and implement reasonable and appropriate due diligence procedures to identify, prevent, mitigate adverse human rights and environmental impacts. And then, of course, related to that due diligence, there's a requirement on commercial and other organizations to publish a forward-looking plan describing the procedures to be adopted in the forthcoming financial year and assessing the effectiveness of those procedures adopted the previous financial year. In terms of liability, commercial and other organizations and their senior managers will be subject to a civil penalty if they fail to develop, implement, and publish a due diligence plan, or they publish a misleading or inadequate plan within a reasonable time. So that's related to the process of due diligence, liability associated with that, with the process. Then there's also commercial and other organizations to be liable for harm, loss, and damage arising from their failure to prevent adverse human and environmental impacts of their domestic and international operations, products, and services, including in their supply and value chains. So, and then it is a defense from liability for loss or damage, unless otherwise specified, for commercial organizations to prove that they acted with due care. So essentially relying on the due diligence that they conducted to prevent human rights and environmental impacts within their supply and value chains. And lastly, apologies that this is the sort of technical piece, commercial and other organizations and their senior managers shall be subject to a criminal penalty if they fail to prevent serious human rights or environmental impacts. So that's our building block on which the research was built. Obviously, the question of enforcement looms large in terms of design of the law, and obviously once the law is enacted in terms of enforcement of the law. And so for our research project, we were tasked with analysing how a dedicated regulatory body could add value to the enforcement of this proposed law by increasing the likelihood of UK companies being held accountable for cross-border human rights abuses, environmental abuses, and providing specialist advice relating to cross-border abuses. And secondly, part two of our research was assessing how such an enforcement body could be best designed to achieve those goals by suggesting what can be learned from existing regulatory bodies in the UK and internationally, but with a real focus on the UK, of course, analysing possible resourcing models, proposing the powers, resources, and methods of operating that a regulator would need to be effective. I won't go into the details of our research project, but suffice to say, full literature review was conducted and we interviewed a number of key authorities on the subject. We obviously drew on the expertise of Kingsley Napley, which is obviously a preeminent firm working on and with regulators. So to touch very briefly on the international picture, as Fiona mentioned, there are obviously existing mandatory human rights due diligence laws, and these take a range of approaches to enforcement, including the use of civil liability provisions under the French corporate duty of vigilance law. And under the Dutch child labour law, what we see is administrative enforcement by a regulatory institution. So that would essentially take the form of a declaration of non-compliance with the due diligence required under the law, and that being enforceable through the courts. Generally, sort of taking it, zooming out even further, the movement towards the adoption of mandatory human rights due diligence laws has obviously stepped up a gear this momentous year, 2020, with the EU consulting on such a law, the consultation ending just in February next year. And the Office of the High Commissioner of Human Rights put out an issues paper in June of this year, which set out a range of enforcement possibilities that are theoretically available. So suffice to say, the question of regulatory enforcement is there on both the international policy agenda as well as being addressed in each state that is considering these laws. But as Robert alluded to at the beginning of the seminar, these questions are still somewhat underexplored, and hence this report and our eagerness to speak with you, those who've joined us at in this seminar today, and to work on this subject further. So to look at what's currently on the table. So in terms of the civil liability picture in the UK, as Fiona mentioned, obviously we do have cases, civil liability cases before the English courts in which human rights violations by corporate actors abroad are being brought. And we highlight that, although in the report we highlight that although a relatively more successful route to remedy than criminal prosecutions, that there are nonetheless significant obstacles for victims in bringing such civil claims. Noteworthy among these are, of course, attributing liability to the parent company or the lead company in a supply chain situation when the harm has ostensibly occurred at the hands of the subsidiary or supplier overseas. And then another major hurdle is establishing liability of the English courts over the case. The latter has obviously been made more complicated post Lungowi and Vedanta in the Supreme Court, and will likely grow more complicated still with Brexit and the UK's exit from the Brussels regulation. There's also a question we draw out in the report about the suitability of civil liability through tort litigation for the whole gamut of different human rights violations in issue. So civil liability through tort claims would not necessarily be well suited to cases where business, for example, contributes a small proportion to an extraordinary harm, for example, companies' contribution to climate change. And also not all human rights have a corresponding cause of action in tort law. In particular, economic, social and cultural rights frequently don't. So the principal elements document that I outlined for you obviously provides a powerful new basis of claim for civil damages for failure to prevent adverse human rights and environmental impacts of companies' domestic and international operations, which will facilitate standalone damages claims capable of issue without regulatory findings or proceedings. So this would be a major tool in the civil lawyers' kit already. But nonetheless, we conclude that there is also a role for a regulator as investigator and adjudicator of complaints resulting in imposition of civil sanction that is complementary to, not a substitute for, civil litigation in the courts. And Sophie will obviously speak more about this. So lastly, turning to criminal prosecutions, and we've heard obviously from Fiona that the picture here is not so positive. As far as known at the time of writing, no companies have been prosecuted in the courts of England and Wales for their role in the conduct of the kind at issue here, so amounting to serious human rights impacts or environmental harm abroad. So our recommendation is that, in circumstances of failure to prevent serious human rights and environmental impacts, and obviously the details are established in the report, criminal investigation and prosecution should occur, with the most serious cases being referred outside the regulator to one of the established prosecuting authorities, most likely the Crown Prosecution Service or the Environment Agency. So we'll come to the details of that function of the regulator again through Sophie's presentation. But just to note here that there are many obstacles. Robert also alluded to one just now in terms of why it is that criminal cases are not coming before the courts in these cases, in these situations. Prominent among these, the difficulty in establishing corporate liability under the identification principle, in particular in relation to large and complex corporate structures. The legal and political limitations to assertion of jurisdiction over overseas criminal conduct is also a huge reason. And then the question or the point that Robert alluded to around under-resourced or underprepared prosecutorial authorities, perhaps the lack of political will for this. So we also note in the report and draw some points out about the fact that on remedy, criminal law generally, and in particular, the current sentencing powers of the criminal courts are not best suited to providing reparations to victims, of serious human rights abuse or environmental harm, as we're looking at here. And obviously in the report, we discuss other measures at the disposal of prosecutors, such as deferred prosecution agreements and their role in the resolution of these serious human rights and environmental harms. We also grapple in the report with the difficult question, and one that I'll leave you with here, about how does the regulator monitor a company's human rights due diligence and environmental due diligence processes? How does that monitoring affect a statutory defence of acting with due care to prevent human rights abuses? So that dual function of the regulator and how that will be managed. But I'll leave my points there, and obviously happy to take Q&A. Thank you.
Brilliant, Rachel. Thank you so much. I just had one follow-up question at this stage, which is, you talk about the background of this proposed law by civil society, and interesting based on this notion of a failure to prevent. How much do you think such a law, and with all your extensive knowledge of the civil
Robert, you froze it. I don't know if that's the same. Has Robert frozen for everyone or just for me?
Yes, I think we lost Robert for a little bit. Yeah, Rachel,
we'll move on to Sophie, and then I can come back to the question. Was that all right, Sophie?
Yeah.
Yeah, let's do that. And then we can come back. Super,
yeah,
thanks.
We're going to me. I'd like to start again by thanking the Bonavero Institute and also Traidcraft for allowing us this fascinating opportunity to work on the regulator report. To me, regulators play such a big role in delivering social as well as economic objectives. And it's interesting to think that there are approximately 90 regulators in the UK with a budget of over £4 billion. And so it really shows how important they can be and are to us in society. And actually, to me, I think it's pretty surprising that businesses are not already regulated and were required to take responsibility for reducing social harm in this context. So coming to our report envisages a regulator which can investigate and adjudicate on complaints brought by groups or individuals, and which is capable of imposing civil sanctions, as well as referring serious cases for criminal prosecution. I think we do, though, really recognise that a regulator needs a varied toolkit, with education and engagement playing a really strong role alongside punitive measures. The report sets out our view on the key features of a business and human rights regulator. But our feeling is really that there's such a significant opportunity for further analysis and modelling, and that the floor is really open to you to take it forward, and particularly to think about how a regulator in the UK can have an international reach, and so that where there's a company with operating a subsidiary, that subsidiary comes into the view of the UK regulator, and I'll talk a little bit more about that. The report does cover a lot of ground, and I really can't go into all the detail in the 10 minutes or so that I've got today, but I'm going to talk about some of the key features and really try to give you a flavour of what a regulator could do. If I just try and present my screen and showcase my technical abilities. So what I'm going to look at today are the investigative powers, including the power to obtain evidence, have a quick look at market investigations, which are a potentially interesting tool to look at in this context. Also have a little look at education and guidance, the role of prosecution and civil sanctions, which might be developed in a business and human rights context, and then look at the role of national and international cooperation. So turning then to investigative powers, we considered that the investigative powers in this context should be those that all regulators, or majority of regulators, have. So the scope of powers that a regulator needs really depends on a number of factors, including the seriousness of the conduct and harm under investigation, as well as the difficulty of obtaining evidence. We thought that the business and human rights regulator is likely to receive and investigate complaints involving serious criminal conduct, causing widespread harm, where it's actually quite difficult to gather evidence. And so therefore, like other regulators such as the Environment Agency, the Health and Safety Executive, we considered that key investigative powers should include the power to require any person, and that includes a company in that definition, to provide any relevant documentation or information. Also, the power to require persons to answer questions. And like other regulators, such as the Environment Agency and the Health and Safety Executive, there should be a power to enter premises with or without a warrant, provided that certain specific safeguards are met. Trying then to think about what those powers might look like in action. I think that we try to model this a little bit, but there is further scope for modeling in this context. And if I can just share with you my slide on the powers in action, we envisaged looking at Company A, which is a UK-based trading company with a controlling shareholder stake in subsidiary B, its Indonesian subsidiary, which operates a number of logging enterprises and whose conduct has led to a loss of ancestral lands and associated rights, as well as pollution of watercourses. Here, in this type of circumstance, we would expect the regulator to be using its powers, which we've just mentioned, to obtain, for example, electronic or hard copy correspondence surrounding the events, documents relating to the relationship between Company A and subsidiary B, but also to bring this into the due diligence laws, to ask for documents relating to risk assessment procedures, any internal measures undertaken to comply with due diligence guidelines. So I hope that that gives you a flavour of what the powers are designed to obtain. Next, we thought more broadly about investigation, not just focusing on those traditional investigative powers. So I wanted to mention one of those investigative tools, which is market investigations, and whether they could be utilised in the context of a business and human rights regulator. I think our view is that it's a really fascinating area, but it does need some further detailed research. And just to give you an example of what I mean by market investigation, the Competition and Markets Authority, which I'll refer to as the CMA for brevity, has the power to conduct a market investigation, which is an in-depth investigation of a whole market, not just an individual company. I should say that's a whole market sector. So they focus on industry-wide behaviours and practices rather than the workings of individual companies. They are long and detailed, and there is some complaint about the length that they take, but they have a really significant impact. For example, past investigations have led the CMA to order the sale by BAA of certain airports and private hospitals by certain private healthcare providers. So I think that is really an area that we think could be explored further, but we didn't have the scope to model it in quite as much detail as we'd have liked in our report. Turning then to another key feature of a regulator, we don't overlook that there is a really very significant role for education and engagement. Regulators like the Food Standards Agency, the Environment Agency, the Health and Safety Executive, and the Competition and Markets Authority publish really extensive guidance on compliance. Interestingly, in that vein, research by the OECD indicates that a significant reason for a lack of compliance by regulated entities is actually a lack of knowledge and a lack of understanding of what they're supposed to do. And from my own personal experience working alongside regulators, after their enforcement function, education and capacity building has been a really significant and essential part of their remit, which not only helps with benchmarking, but it really helps bring up standards within either professions or sectors when that kind of engagement takes place. But again, it's not just about engagement and education. There is, sadly, as Fiona alluded to, some really serious conduct which requires a more punitive approach, and we do anticipate that criminal and civil enforcement mechanisms will need to be available. Rachel has talked about the criminal prosecutions and the availability. I wanted to flag here what I consider is potentially the scope for the novel use of civil sanctions, which are powers given to certain qualifying regulators by the Regulatory Enforcement and Sanctions Act 2008. It's used extensively by the Environment Agency in areas such as fishing, oil storage, but also waste packaging. And some of the examples that we consider in the report include variable financial penalties of up to 10% of turnover. This is also used by the Competition and Markets Authority. Also interesting are something called enforcement undertakings, which encourage corrective behaviour where an entity has failed to comply with due diligence guidelines. We also looked at third-party undertakings where an entity might promise to compensate those affected by human rights violations. So that's coming back to what Fiona mentioned at the beginning about using a financial penalty as a punitive measure, but also to provide compensation. And very interesting, I think, are restoration notices, which are particularly used in an environmental context. And these require specified steps within a stated period of time to secure restitution as far as that is possible. Going back then, if I might, to looking at our civil sanctions in action and our company, our fictitious company A, if I can just get my slide for you. We looked at what might happen if company A was successfully prosecuted by the regulator and an infringement finding was made. And we thought that a restoration notice might state to try and provide, to make company A take action. We might impose something like the following. So company A must not exercise any shareholder voting rights in respect of subsidiary B, which of course subsidiary B is in another jurisdiction, until subsidiary B has ceased its illegal activities, subsidiary B has returned ancestral land rights. In the alternative to B, where ancestral land is unusable, company A and subsidiary B are to provide basket funding of an appropriate sum to a designated community fund. And that type of option is available in a situation where the ancestral land rights are no longer usable by the persons concerned. We also thought that there might be scope for independent auditors to play a role, and so that subsidiary B had to satisfy any independent auditors that operations are compliant with business and human rights due diligence guidelines. So we recognise that that is a novel approach, and it's worth mentioning that although it is novel, we do think that the regulator can fairly reasonably and lawfully be given that kind of statutory power to prohibit certain business activities taking place in the UK until the regulator is satisfied that its foreign subsidiaries have complied with requirements requiring cleanup and environmental restoration and compensation if that's appropriate. So those are some of the kind of key powers and key punitive sanctions which we thought might work. I'm just very briefly going to touch on two other factors which I think are interesting for you to think about. The first relates to national and international cooperation and capacity building. cooperation between domestic regulators is really important, and you've got the example of the Competition and Markets Authority, which has joint responsibility for enforcing the Competition Act within the UK. And we thought it would be interesting to look at the extent which you could have concurrency arrangements between, for example, the Environment Agency or the Crown Prosecution Service, so that the shared expertise of a business and human rights regulator, but existing prosecuting authorities, could be developed and work in tandem. And a slight side point, but the Regulatory Futures Review, which is conducted in the UK recently, also thought that there was much more scope for regulators to work together in this type of situation. We also think that international cooperation will be crucial, and we strongly anticipate, as we're seeing in Europe, that a national business and human rights regulator is part of building towards a transnational coalition of enforcement agencies, and in a sense, the coalition of the willing that is needed. That's capacity building. There's also the really difficult question in my mind of where to start and what the key priorities are going to be. In that context, I think it's worth noting that we recommend that the enabling legislation of the business and human rights regulator should include formal powers which permit the regulator to ask the Secretary of State to change its powers so that it can change the scope of its regulation as is required over the years to allow it to expand to respond to changing circumstances. And there's also a procedure which I won't go into now too much, but it's called a post-implementation review, which allows a regulator to consider the extent to which it is achieving its policy objectives and the measures it's using are achieving those. So in that context, there really is scope to think about the regulator growing over time to expand its priorities and really work with civil society groups, businesses, and wider society to make sure that it does grow to encompass and properly tackle the mandatory human rights due diligence laws, and also to make sure that serious harm is properly brought to justice. That is it from me. I'm not sure if we've got Robert rejoining us yet.
I don't think so. Well, thank you very much, Sophie, for outlining the key points of the report. And I can see that Robert is just connecting now. Robert, are you on the call now? Do we have you? I can see the play with your name. Hi, Robert.
Hello.
Hello.
Apologies, everyone. This has been a bit of a disaster, and I'm sorry. I've now lost myself.
It's all right. Well, we're just getting to a Q&A point. So Sophie just finished her presentation, and thank you very much for outlining the key points of the report. So I will just put 3 questions from Q&A box to each of the speakers, and then Robert, you can pick up from where we are.
That's brilliant. I apologize. My whole computer decided it had far too many Zooms.
Absolutely, no worries. It's been a very weird and strange year, getting to the end. But so with the questions, we got few of them. So Fiona, the question for you is, what is the next step in bringing about the legal changes recommended in the report? And how do you see a broad campaign in which individuals and organizations can be involved? Rachel, your question will be about the Canadian experience of the business and human rights ombudsperson and how it can impact on the proposal that you and your colleagues have prepared in the report. And then finally, Sophie, if you can tell us about a little bit how you think the regulator can build upon all of the existing mechanisms and existing successes or issues that have been arising in the courts, and we have seen few cases on civil liability for human rights violations, whether the regulator's role would be complementary to these proceedings, and also how it fits in within the work of the national contact points. So Fiona, can we start with you, and then Robert will pick up on that. Thank you.
Thank you. That's brilliant, Katja.
So thank you very much for these brilliant questions that are coming in, and please post more because they're really useful. So the question about how to build on this, essentially, there are two things that we need to look at. One is what is going to happen with Brexit. That may or may not have an impact on our legal landscape. Then my second point is that I would very much welcome different civil society organisations, think tanks and others interested in improving human rights and also the environmental performance of companies in a meaningful way with hard law, raising awareness with MPs, the need for this law and building essentially a campaign together. I think the logical coordination place for us all is through the CORE coalition, which is the Corporate Responsibility Coalition. And I think that is the logical place for us to be. So as of January 2021, I hope that we can build from there. I am wondering if I should also answer the question about the national contact point, because we're going to run out of time very quickly.
Yes, please.
Yeah, so the national contact point at the moment is only able to issue a report if the company cooperates. That's how sort of pathetic its setup is. So there's no investigation. And given that there's also no possibility for any enforcement or revision of the company's actions themselves, that means that anything that we do to change the national contact point or anything else would require primary legislation. If we need primary legislation, then we should go for a dedicated law with dedicated enforcement. So I see that the national contact point might become an interesting mediation point, but I don't see it necessarily evolving very smoothly to having decent quality enforcement. That requires primary legislation, and then it makes sense to have a dedicated law with dedicated enforcement. That's it from me.
Thanks very much, Fiona. I could just add on the NCPs, of course, there's also the issue about what remedy they actually do provide to victims, because there is an extensive report undertaken on the UK national contact point by Amnesty International, in which they showed just, I think there was one actual remedy for a victim of all the various NCP activities, though I think it has been reformed more recently, and we'll see whether that improves that. Thanks very much, Fiona. Now to you, Rachel.
Thank you. So just on the NCP point, obviously in terms of building up capacity for companies and understanding the nature of their due diligence obligations, one can imagine utilising the OECD's materials, for example, their sector-specific guidance on due diligence. So that being a route of sort of coordination there. But yes, I agree with you, Fiona, about the sort of limitations of the NCP as it currently stands. So to answer your question, Peter McClinsky, about the Canadian experience, thank you for the question. I think, and obviously feel free to update me if I'm sort of out of touch, but certainly my sort of understanding has been that this process in Canada has become largely politicized, and there have been weak political appointments in terms of who has been selected to be the Ombudsman. And this, I think, points to an important aspect of our own research and a concern that was raised with us during our interviews and the consultation that we did for the report around ensuring political independence and actually just ensuring that the regulator has teeth and does what's being asked of it. So this is something I'm sure Sophie will come back to again, but suffice to say that we do have regulators in the UK that have teeth and that are successfully curbing corporate misconduct in different contexts. And so that's why we need too must be a limitation under the proposed law. So the law must be criminal, must be clearly defined, not just the criminal act, but the accompanying state of mind. And in order to focus on the most serious cases, in the report, we put forward the suggestion that the legislation should apply only to where the predicate criminal offence carries a maximum sentence of imprisonment or a specified period of time, for a specified period of time. So looking at what that seriousness amounts to and putting forward a proposal on that, but we would welcome your intervention and we can follow up. Certainly my colleague Katherine Tyler, who's obviously worked on a lot of the criminal law side of business and human rights, would also be happy to engage with you on this as well. And then your question about which senior managers, and that's also a very important question and one that we addressed our minds to, not least because again, with the failure to prevent legislation currently in place, none of these offences makes provision for the prosecution of individuals for their part in the company's failure. So a question in our minds was, how will liability be attributed to individuals for corporate omissions in this regard? And obviously we have in anti-money laundering legislation a particular role created for a nominated officer, that conventionally the money laundering reporting officer, who having been sort of so identified can be made more easily accountable. And we also see in the Netherlands, for example, with the child labour due diligence law, again, a nominated individual or individuals within the company who themselves potentially could fall liable were the provisions not complied with. So I hope I've answered that to a degree, but more in terms of interaction would be good on this point. I'll leave it there and we'll come back to some more questions from me in a moment. Over to you, Sophie.
Thanks very much, Rachel. That's really good. And as you said, Katherine Tyler will follow up, Martin, with your question on criminal matters. And now to you, Sophie.
Yeah, so I am going to deal with the question about how the regulator would fit in with existing civil liability frameworks. And also I've seen a couple of questions about how it would fit in with existing regulatory frameworks. So I'll try and tackle both of those. So firstly, then, existing civil liability, and obviously there's the Vedanta and the Pavi cases in which claimants are seeking to go down the civil claim route to achieve liability. And we're really conscious that the regulator shouldn't stop that, and that a regulator should be complementary to allowing claimants to seek damages through the civil courts. And we looked at the competition regime, which so under the Competition Act 1998 and its section 47, if there is an infringement found by the regulator in that context, a claimant can make what is called a follow-on damages claim. And we can see great benefit in that, in that it allows the regulator to do the work of investigation with its investigatory powers to obtain information, to make a finding and an adjudication. But then with that finding, we hope that a claimant could then utilise the judgments and the findings in the civil court to seek damages. So we anticipate that would be a mechanism which could be used in this context. Looking then at the other question, which is about how the business and human rights regulator would fit in with the existing framework, there's the question from Desiree Abrahams about coordination of regulators, and also from Mark Mills about how whether there should be just a specialist regulator or whether other regulatory bodies should take on responsibility. I think this all falls in the same melting pot to me, which is that we did think about whether you should parcel up regulation and so particular sectoral regulators take on responsibility for looking at human rights within their sector. But we actually thought that it's really desirable for a business and human rights regulator to develop particular expertise in investigations in a particular context. And for that reason, we came down on the business and human rights regulator. But we do recognise that a lot of these issues will cross-cut, and we do think that there ought to be some information sharing mechanisms between regulators. And that, again, I mentioned the Regulatory Futures Review. That was another report which talked about how important it is that regulators share information to enable a more joined up and consistent approach. And so we would recommend that. but also you can look at concurrency arrangements, which I looked at, and again that's a feature of the Competition and Markets Authority. A number of regulators like Ofcom and Ofgem have powers to investigate the competition offences in that context, and that can be considered whether it would be appropriate for another regulator to take this up, but have concurrency arrangements so there could be a discussion between those regulators about who would be best placed to take it forward. And it might depend on who has the best expertise in the context of the case, but in short, we think a specialist regulator is needed to gather the expertise and become really expert.
Thanks so much, Sophie. There's still so many coming in. There's quite an interesting one about I have to say something I don't know much about, that Desiree Abraham was asked about the International Code of Marketing of breast milk. I suspect to some extent you've covered this, Sophie. Are you able to clarify that point for us?
I don't know anything about the particular context, I'm afraid, but I'll certainly see if I can provide a more considered response afterwards. But I do think it sort of falls within this point of there needing to be, and well, the difficulty that Fiona alluded to earlier about particular events falling between two regulators and who's best placed to take it up. And I think that is a challenge for a business and human rights regulator, to decide which body is going to be best placed. But I think that's, in a sense, all the more reason for a single specialist regulator which can decide whether something fits within its remit and then forward, if it doesn't, to a regulator, a more specialist regulator, which might be best placed. But in that sense, we think a business and human rights regulator will, in a sense, educate others, other regulatory bodies, so that they're in a better position to understand what is required in any given situation.
Thank you. There's also an interesting question which Rachel Widders has asked. I'm not sure whether it's you or perhaps Fiona who can answer this, which is a link between the regulator and disqualification from public procurement. In that one of the issues very often is that we could do with incentives in this area, and even incentive is for a company to comply, then it would, which enables them to have access to public procurement. Then a possible disincentive would be if they're found by the regulator to be acting contrary to the what's expected, that they would be disqualified from public procurement. Sophie, is that within your breadth of expertise, or should I ask Fiona?
I think, why don't we let Fiona take that one now, or if she'd rather not. I think I'm happy to kind of respond to it as best I can now. But I think that in terms, yes, I think the answer should be that a regulator would fit into a public procurement framework. But as with a lot of these issues that we encompassed, it does need more modelling and scoping. It's an exceptionally broad piece, in a way, setting up a regulator in this context, and it interlocks, as we've discussed, with a number of different legal frameworks. And this is another example of a legal framework in which a regulator would interlock. And so there definitely is scope for procurement to be brought into it. But again, it needs that further research and modelling, which we didn't have the opportunity to go into in detail in the report.
No, of course, and you covered a great deal. The issue of funding the regulator, though, what's your thinking on that?
My thinking on it is that it will need really substantial funding, and we looked at funding the Environment Agency. Its budget is over £1 billion a year, so it shows you how much is needed to take forward kind of proper regulatory enforcement action. Also, I think in funding you need a principled method of funding, and it can be shared between Treasury budget, but also you can look at something like the payment system regulator, which operates by introducing a levy on companies. So I think we think that there would need to be a combination of Treasury funding and a levy, but it would need substantial funding, and that's one of the key things. You need a regulator with teeth, and to do that and to investigate it costs.
Thank you. That's a really helpful context for this. Fiona, back with you. Firstly, just maybe a comment on the funding, on the basis that obviously you're working with a range of different groups on this, but also Peter Frankenthal has asked a question. Do you have any thoughts on that one?
So just on funding, we don't know which businesses are going to fall into scope initially, but I would suggest that where there is a track record of malpractice by a range of businesses, those businesses fall into scope. What we noticed when the Grocery Code Adjudicator was established, that because they had had a track record of malpractice for a number of years, they contributed to the funding of the regulator. And the interesting component to that regulator is that where an investigation happens, that regulator is retrospectively able to put the bill of that investigation with the regulator. So that aspect of an investigation, which is very, very, very expensive, doesn't necessarily have to be funded by the government. It could be Treasury neutral. And I think some sort of flexibility in this space is interesting. Obviously, the regulator must be independent of the companies, so that the way that the levy for that Grocery Code Adjudicator works is that the money goes into government and then BEIS gives the money to the regulator. So I don't think that costs should be the barrier. In fact, costs could act as part of dissuading the businesses for continuing with malpractice. And in fact, you can construct funding in such a way that businesses that behave well pay less in a levy, and those businesses that occupy a regulator's time enormously have to pay more. I wanted someone else to answer Peter Frankenthal's question about disclosure, because I think it's really important. So I'm sorry for ducking that one.
No problem, understand. Maybe I'll move on that one to Rachel. And Rachel, is one of the other questions here, which I think is directed to you. If you could also answer that, thank you.
Thanks. Yeah, thank you for all these really interesting questions. And rest assured, if we don't answer them, first of all, we'll be saving the Q&A and we'll come back to you. And also we'll be thinking about how to integrate your thoughts into our future research. So thank you so much for your questions. So first, turning to, I think I pronounced it Mexico. If I pronounced that wrong, I apologize. You asked, do you think governments of host countries should be roped in for the success of these kind of laws? The answer is yes, and that comes back to the point Sophie raised about mutual legal assistance and about the role of, in cross-border investigations like this, of cooperation. We realize this is a challenge. Certainly that has been the case, for example, with enforcement of the Bribery Act. And while, of course, there is sometimes cooperation, this isn't necessarily the case. For example, if in the case of the Bribery Act, the state in question, it's still the same regime or government that was implicated in the bribery that's in power there. So it's not straightforward, but yes, it's an essential component, and I'm glad you stressed it. Gustavo, you asked a question about jurisdiction of the courts in civil claims. So we have the principal elements document that I mentioned, and then there's a commentary to that kind of puts some flesh on those elements. And what you can see from that is that jurisdiction is, as it is at present, based on domicile. So although obviously with Brexit the UK will leave Brussels regulation, nonetheless, the principles of jurisdiction will remain the same. And so you'll have companies domiciled in the UK being sued in the UK, and then the arrangements whereby subsidiaries can be joined as parties, assuming that they meet the proper criteria for that. So although, as Fiona mentioned, for the broader due diligence obligation, the intention of the principal elements is that this applies to a greater selection of companies than just those domiciled in the UK, so those doing a measure of business within the UK. That there's a distinction there between those companies that fall under the due diligence obligation and those that can be sued in the civil courts. And then turning to Isadora, your question about the position of victims and their important place within criminal proceedings you mentioned, but I mean, even more, assuming a regulator is put in place, again, how can their voice be heard? And, I alluded briefly in my presentation to the sort of drawback of criminal law that, it's not intended to provide remedy. And while, for example, in sentencing, one would have a victim statement, and we do see some interesting developments, for example, principles developed around considering how to use when bribery is found, how to allocate fines to people who've been affected in countries overseas. You'll find information about that in the report. But in terms of victims' voice, I think this is, something to think more about, and also to, to build into the design of the regulator. I think I'll stop there. I mean, I could keep going because there's lots of interesting questions, but I'll pause and then let one of you, I can always come back for more.
Thanks very much, Rachel. That was covered really well, a range of different things. Fiona's volunteered to have a look at the question about smallholders and home workers, which is a very interesting question, in a sense, raises some of the broader issues which you don't always think about. And to some extent, COVID has made us consider these things more closely. So, Fiona.
Thank you. So what I wanted to reply is, this is how we want the law to work. We want the law to result in a business to positively think about where human rights violations might happen. So if intrinsic to making your product, you emit noxious gases, or which would impact on someone's lungs and possibly kill them, or if you have a process that obviously has a track record of severe human rights harms because it involves security around your premises, then it is forcing the business to think whether or not it is managing those operations in such a way that it will not lead to that human rights violation. That's the point of it. It doesn't matter whether or not it is a large-scale farm or smallholders. You need to do your pesticide control well to ensure that the large-scale or the small-scale farmer is not going to be poisoning themselves. It doesn't matter if it's small or big. And the same would apply to home workers or in factory premises. It's all about whether or not the business sitting here has decided it is going to put in place good quality management practices to ensure that that violation doesn't happen, irrespective of who ends up doing it far away. It is true that the controls over smallholders and home workers is less, but it doesn't mean that it's impossible. It's essentially an element of UK businesses choosing not to know at this point in time. So I'll be quiet now.
Thank you. That's a really good way of integrating these issues. That's great. Peter Frankenthal has asked a question about companies and the issue about how they might respond to all of this. Sophie, are you able to respond to that from your breadth of experience? Thanks very much.
Yeah, certainly. I'm sure that companies will fight back on disclosure requests. It's part and parcel of regulatory life. And I'm indeed, having worked both for and against regulators, I've been on both sides of it. I think as to whether that any information obtained is admissible in future proceedings, it is provided that it has been obtained lawfully, fairly, and is relevant to the issues at stake. And so, yes, I anticipate that information provided it was obtained appropriately and is relevant should then be able to be used in future proceedings. There was also a question about the role of victims in...
Just before you get on to that, just pick up a bit further this question of disclosure. I mean, in your experience, is it the case that, say, in other regulators, say such as ones dealing with corruption or those kind of areas, there has been use of the information disclosed to the regulator in court cases?
Yes, I mean, in across a range of proceedings, information obtained through search powers is used, provided that it isn't tainted in the process of it being obtained, and that is a key area for the discussion. But also in the context of public inquiries, there are really significant powers to compel information by the use of statutory powers, which is then admissible and used in court proceedings. So it is a tried and tested route for all parties. And that's why I think it's quite surprising that these type of investigative powers haven't yet featured within the business and human rights context.
Helpful, thank you. Sorry, I'll let you go on to the second question about security.
Yeah. The other question was about rights holders and other stakeholders and their role in establishing a regulator, I suppose. And yes, there should be a mechanism through which consultation takes place and different participants' views on the scope and priorities of a regulator are considered. So, for example, the Food Standards Agency has a really good example of a 3-yearly business plan, and it regularly consults stakeholders about what its regulatory priorities should be. And that kind of process is a really valuable tool for a regulator to take into account what is happening on the ground in connection with human rights abuses and where it ought to be focusing its attention. I mean, I also think it's right that it will consult businesses and those who are engaging in good practice, because there are, as we know, some good corporate actors who should be consulted, and they're quite important from the context of benchmarking, so that we can see what good practice is and what companies are capable of doing. So I think consultation is a hugely important part of it.
Thank you so much, that's really helpful. There's a couple of other questions, well, still quite a few questions coming in. Fiona, you've got a question which you're looking at how this links in with the Environment Bill, and it was a particular section in the Environment Bill which is on sort of forestry commodities, and there's a question about that which talks about given government has recently introduced amendments to the Environment Bill to provide for a limited form of due diligence in relation to forestry commodities, what we often think of as deforestation. To what extent do you think that legislation involves a suitable vehicle to bring in human rights due diligence? Yes, bringing in the question it talks about FPIC, which of course stands for Free, Prior and Informed Consent, particularly in relation to Indigenous people. Your thinking on that, Fiona?
So thank you very much, Jake, for your question. And we are delighted with the Environment Bill looking at this, and we think that the links between environmental harms are very close to human rights violations. Sometimes there are communities who are entirely dependent for their livelihoods on what is essentially environmental resources, be it forestry or land. So we would very much welcome the British government expanding the scope of the Environment Bill if there was the political will to do so. And certainly NGOs have been looking at the possibility for that. I would say that any discussion about due diligence, like we've been having here, mainly in the human rights space, obviously raises questions about enforcement. So there is the possibility that as this Environment Bill looks at due diligence for environmental harms, specifically obviously forestry in this case, then it would be wise for them to think about setting up a regulator, a bit like what we're talking about today, to ensure that this is not a toothless piece of law, but actually has some mechanism for enforcement. So I'm in support of your suggestion to widen it. And so far, I haven't seen political will to support the widening, but I would be in support of it. That's it.
You also make the point, of course, of the link between human rights and the environment, which in a way is also interesting because the European Commission's proposal almost certainly will include environment as part of human rights due diligence. And that links into a question Alison Bissett has asked about what does this mean? You know, how does this proposal link in with what the European Commission are proposing? And I'm going to take the chair's control and answer that question myself, having been very involved in the study which led to the European Commission's proposal. I guess my answer is that the Commission itself, in its various ways of engaging this, does ask at one point in that rather lengthy and confusing questionnaire about some form of enforcement, and in that refers to what's in the rest of Europe largely considered what they call a supervisory mechanism rather than a regulatory mechanism. It means the same thing. In fact, a colleague of mine in the Netherlands and I are writing about how the two could work very well together, and that you probably also need a European body to overlook what each of the member states would be doing in terms of a supervisory mechanism. And that supervisory mechanism is very well known across many of the other European states, so often not necessarily operating smoothly. Of course, the big question is whether or not the UK would follow whatever the European Commission might do on this area. So that's my kind of input to that. Now, you'll have to, my wonderful colleagues here will have to tell me if there's some, I see another question just come in from Sarah Platz. Question regarding the gender issues of corporate harms. Corporate social responsibility tends to focus on environmental issues and social harms, human rights. I think often at the expense of the more particular issues of violence and abuse inflicted on women in communities. Do you think there's any scope for a regulator to help in this way specifically? I wondered, Rachel, if you were able to answer that, because you've got some experience in looking at, say, how some of the discussions out of the working group on business and human rights have dealt with gendered issues. Is that okay?
Gladly. I mean, it may be also that the others have something to say, but I think suffice to say on my part that my understanding that is that, you know, by focusing on thematic issues as the proposed regulator would do, exactly this kind of subject could be the focus, where we see so much international expertise through advocacy organizations and through international organizations, and, you know, a sense that, you know, we could, you know, that the regulator could make significant progress on this particular issue because of that. So, I mean, obviously feel free to add anything to that, Sophie and Fiona, but I think that would be my sort of starting point there. I don't know if I have a chance to answer one or two others. I don't want to kind of jump on other people's time, but I'm just quickly on going all the way back to procurement. So sorry to leap around, but I just wanted to mention that certainly with Canada, when procurement decisions are made, they factor in decisions of the NCP, so the OECD National Contact Point. And so you know, there's obviously an area of research and interest about how to ensure policy coherence with respect to procurement. We see fantastic academics such as Olga Martinez at Greenwich in the UK writing on this. So just to say, I think this is an important issue to come back to. And then this question about you know, other regulators. So coming back to the Environment Bill, and you'll see in the report that we talk about, for example, what's being put in place for the, or has been put in place for the conflict minerals regulation coming into force next year. So the provision of competent authorities, you know, so we, as you'll see in the report, and I hope if you haven't had a chance to read it, all those attending that you will, and that you'll come back to us with your comments again, which we would welcome. You know, we've looked at what's currently being, you know, currently on the table. Obviously, we have very light touch regulation with respect to Section 54 of the Modern Slavery Act in the UK. So looking at what's currently there, obviously identifying some real gaps there, but nonetheless interested, you know, to see, first of all, what we can build on, and secondly, how the cross-fertilization of different regulators will essentially build the expertise of the business and human rights regulator, the point that you made, Sophie. Thanks.
Thanks very much. Sophie, I'm conscious of the time. You've got a couple of questions, but please can you answer whichever ones you choose to answer?
Yeah, I was going to answer the conflict of laws question. I think in many of the rights abuses that we're talking about are serious criminal offences, and so, for example, serious harm or murder is the same in most jurisdictions, and therefore we don't anticipate a conflict of laws in the most serious cases. But yes, we agree that that issue may well arise in other cases, particularly in relation to kind of compliance with mandatory due diligence guidelines. And so we think that that's going to be an area for the regulator to grapple with, like regulatory authorities do in practice now. but that it shouldn't be a reason to stop us trying to enforce laws in this kind of novel and international way. But we do need, it does require the regulator to become specialist and become expert so that it knows how to deal with these situations as they arise.
Thank you very much. Now I have one more question, which goes to Fiona, which is, what next? You've created this fantastic idea, which led to this wonderful report. So what's next?
Thank you, Robert, for the question. I think this discussion that we've had here will enable us to refine the proposal for the regulator. The reason for commissioning this research was also because we had gone to some MPs who were also qualified as lawyers, who acknowledged that we had a serious problem in the UK in terms of enforcement on companies, but would not come out in support of regulation on companies unless they could actually imagine how enforcement would work. And thanks to Sophie, Rachel and Katherine, we now have a report that is the model that we can work with and from. And so huge thanks for that. So I think basically in the new year, we will be able to regroup as a bunch of NGOs. And it wasn't just us, it was a whole number of different organizations scratching our heads, including some of the people who asked us very good questions. So thanks to the questioners. That has led us to this point, and then I think we need to think about campaigning. My dream outcome is that this regulator is set up with the powers that it needs, and then it expands in scope as it needs to. We could potentially have a mining specialism within this regulator, and in due course we could have a purchasing specialism in this regulator. We can see that it could evolve in scope. So I would like to welcome everyone who has been on this call to join Traidcraft Exchange's campaign network, because we will need to campaign on this. So if you are in support, please join us and encourage then MPs to actually pass legislation to set up the law with this type of regulation. Sorry, long answer.
Great answer, and you've put the whole situation really well. Now, I'll now conclude, but before I do, two things. Firstly, obviously, thanks to Bonavero, and particular thanks, though, to Katja, who came in at the last moment when my whole computer just decided it had too many Zooms. So thank you, Katja, for that. And particular thanks to the wonderful presenters who managed once again to cope with my odd absences and occasional returns. But also want to thank the participants. I mean, we had over 100 of participants asking great questions, really perceptive questions, which is exactly what this kind of seminar should be about. So I'm thrilled that it's gone forward. I really, really want to thank you so much for it. And we will have the video recording will be available. So thank you so much, Fiona, Rachel and Sophie, and thanks to Katherine in absence. I really, really appreciate all you've done to make this such an important and innovative idea, which you've captured in a way which can be taken forward. So thank you very much. With that, bye.
Thank you, Robert. Thank you, everyone.
Yeah, thanks, everybody.